Hey, wait a second. That was an earlier deal?
Yes, it fell through on.
I fell through.
Yeah.
Okay. What are we doing today?
We're going to do 6 years TDC on cap.
Why don't you say that? We'd have probably done in 6 years.
Oh, back then we did.
We had a pre-sentence report and everything.
Yeah, it was issue.
That was January. Oh gosh, that was a year ago. You've been in jail for a year since we were up here. Just
Got some good credit built up.
yeah, but
We checked the predator.
we'd rather be working somewhere and taking care of family and building credit that way. All right. Let's take them in numerical sequence with this 23 CR 2000, and that is deadly conduct, discharge of a firearm, a third-degree felony, and then we will pick up 23 CR 2001, second-degree felony of aggravated assault. You are Cameron Smith here with John West, your attorney, and the state's attorney. Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
Yes, please, John.
In summary, 23 CR 2000 alleges that on or about October 22nd, 2023, in Jefferson County, Texas, you committed the third-degree felony of deadly conduct by discharging a firearm at or in the direction of a vehicle, and you were reckless as to whether the vehicle was occupied. Do you understand what you're charged with here? This is a third-degree felony if convicted, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 6 years in prison to run concurrently with the next case, 2001. Are we going to do 6 years as well on that one?
Yes.
Okay, those will run together. Is that your understanding of the agreement? If I follow this agreement of 6 years to run concurrently with the next case, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty? I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents all true and correct? State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Now, pay attention on this because this, what I'm about to say, applies to this next case as well.
Yes, sir.
In 23 CR 2001, when we get a plea from you here in a few minutes. This, as well as 2001, the same document, it states that you are mentally competent to enter your guilty pleas today. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer in each of these cases. All of this is true, so help you God. Is that true?
Yes, sir.
State's Exhibit 1 will be made a part of the record in each of these cases. And let's go to 2001. In summary, this indictment alleges in 23 CR 2001 that on or about October 22nd, 2023, the same day, you committed the second-degree felony of aggravated assault with a deadly weapon. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached again in your case that you would be pleading guilty, sentenced to 6 years in prison to run concurrently with the preceding case that we went over. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this indictment? Guilty or not guilty?
Yes.
You're pleading guilty voluntarily and because you are guilty. And again, the agreement is you would be pleading guilty 6 years in prison to run concurrently. I want to show you what's marked as State's Exhibit 1 in this case. So you recognize it, sign it, and is everything true and correct here? State's Exhibit 1 tendered into evidence without objection admitted. And just as before, you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any of us included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the recommendation, with the representation of you by your attorney. All of this is true, so help you God. State's Exhibit 1 in each case made a part of the record. Pre-sentence reports are waived.
Please, sir.
I'm going to follow these agreements. In each of these cases, Mr. Smith, you have pleaded guilty voluntarily. You were mentally competent.
At this point, everything becomes real. The judge isn't talking about possibilities anymore. He's locking in the outcome. 2 separate felony cases, both ending in 6-year prison sentences. This is where plea deals stop being theory and become life-changing reality. One decision earlier in court has now turned into years behind bars.
Fully competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea in each case, supported by State's Exhibit 1, to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt in each of these 2 cases of the 3rd-degree felony of deadly conduct, discharge of a firearm, and the 2nd-degree felony of aggravated assault with a deadly weapon. I am following these agreements, and I find you guilty beyond a reasonable doubt. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years in each case. But we're not through. You know, we've got one other thing to do. You are charged with using a firearm in each of these cases. So an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of these offenses will be an affirmative finding in these judgments. That will affect your time for parole. But it's again based upon the importance that the legislature placed in firearm usage. You have to use use firearms. It's part of the Constitution. You have a right to a firearm, but it has to be used responsibly, not as a tool to commit crimes. When you use it responsibly, it's fine. When it's irresponsibly used, like in these cases, you pay a price and your parole is adversely affected. You won't be paroled until 50% of your time has been taken care of and served in each of these cases, which is 3 years.
Yes, sir.
Anything else to add? That is all. Thank you.
And just like that, the courtroom closes on another major plea deal case. No trial, no jury fight, just negotiated sentences that shape the next several years of this defendant's life. It really makes you think in cases like this. It's a plea deal, a smart escape, or just controlled consequences instead of uncontrolled risk.